is listed in there, and the factor has that factor lists a lot of different kinds of professions and the types of first responders that the factor applies to. We deleted all but the law enforcement officer because there are none of those others that are relevant to that. When we use that charge, that would be, I think, the number 4 on our aggravators. That's the murder was committed against any law enforcement engaged in performance of official duties. We omitted the other, and I think that would be appropriate. Is there any objection to the wording of that?
No, Your Honor.
And then the other factor was on mutilation of the body, which is defined, said knowingly mutilated the body of the victim after death. And the knowingly definition that we used is the same as the knowingly was defined in the abuse of a corpse charge. Any objection to that?
No, Your Honor.
All right. Then both sides have submitted a version of mitigating factors that the court is required to consider. The court had drafted some changes to those that the defendant had submitted, and we'll deal with those. But Mr. Evans, you had indicated, I think, to Ms. Jones that there was an issue that needed to be addressed, and you want to address that now?
Yes, Your Honor. The issue, microphone.
Sorry, you can just stand on one side or the other if you want to.
Thank you, Your Honor. The issue that's come to light is in the way of rebuttal. Deputy Calhoun testified yesterday that he had witnessed Mr. Wiggins back prior to him entering custody in this case, and that the back tattoo that said "Crush your enemies, show no mercy" was not there. If Your Honor may recall, one of my initial arguments that we had not received any copies of any body camera footage that he claimed to was in existence that showed Mr. Wiggins' back at the time where that tattoo would or would not have been. Since that time and overnight, we've come across information to show that testimony by Detective Calhoun, or Deputy Calhoun rather, was false. In fact, there's pictures noting that tattoo was in existence on Monday, October 27th of 2014. So I've raised that issue with the state, and it's our agreement to enter in a stipulation to that fact that could be read to the jury. We don't have one typed out, but that information was inaccurate.
So if I'm understanding you correctly, both sides are in agreement that the stipulation would be that the testimony of Deputy Calhoun was inaccurate as to the back tattoo, and that in fact that was in fact present on the defendant's body prior to the crime involved or the time period when he was incarcerated for this crime.
Yes, Your Honor.
Do you want to word that in such a fashion, or yourselves, or do you want the court to come up with a stipulation? Obviously, the stipulation needs to be that both of you agree to, but
Judge, and the state agrees that just the back tattoo was likely there before he went into custody on this count. We're not agreeing that in any way that Deputy Calhoun's testimony was intentionally false or incorrect.
I don't
In
think
fact,
it's appropriate to say that it was false. I think it would be inaccurate would be the correct word to be used.
And to clarify, the death row tattoo is absolutely not there when he goes into custody on this case. So it's only one tattoo at issue.
So my question then is, do you two want to draft a stipulation that you want read to the jury, or do you want me to draft something? I would prefer that it be, since it's your stipulation, that you draft the language of it so that I'm not involved in it, since it's your stipulation. But I do want to have that done so that we can address the jury before the closing arguments are made. So we'll let you work on that, and then let's move to the charge itself. Other than the language regarding the mitigating factors that are required to be considered, and of course the law, as both sides know, the law requires me to charge the jury regarding any mitigating factors that are fairly raised by the evidence. The 5 aggravating factors are included in my charge, my initial draft of the charge, and those are the ones that contained within the notice of intent to seek the death penalty. And I find that the evidence is sufficient for those 5 aggravating factors to be submitted to the jury for their consideration as to whether or not the state has proven beyond a reasonable doubt those 5 aggravating factors. Then the only question becomes the mitigating circumstances or mitigating factors. And the defendant has submitted, I think it is somewhere around 14, 15, 16 different aggravating factors. The state has now, mitigating factors, I apologize. The state has now submitted their proposal, and I will be glad to hear your argument on any of this. It is the court's requirement under the law to charge the statutory mitigating factors and any other mitigating factors that are fairly raised by the evidence. I would like to give you an opportunity if you want to address those in general, specifically, or however you want to do it. And then let us get those defined, a decision made on each one of those so that we can get the final charge ready so that before you actually begin your closing argument to the jury, you have my final draft of the charge, which includes both aggravating and mitigating factors. So, Mr. Wyatt, for the state, is the one who submitted I believe he signed off on this motion asking for the proposed mitigating circumstances, but you want to address each one of those?
Please, Your Honor. And for the record, I filed an amended motion to this just recently electronically while we were in here upon further review of the cases that I've cited. As Your Honor stated, the defense has submitted 16 factors for the court to consider, the last of which mirrors one of the statutory factors, which is kind of a catch-all. Your Honor, the state is relying upon State versus Odom, which is 928 Southwest 2nd 18. And in that case,
The original draft of the defendant's proposed mitigators. That's fine. I'm sorry.
and starting on page 31, in this case, there's also a footnote, footnote 12, that the court lays out, the Tennessee Supreme Court lays out the defendant's special instruction request. For instance, the second one is, you may consider the defendant's family background, history of abandonment, adoption, child abuse, or any other circumstance of his life in deciding whether or not there are mitigating circumstances shown by the proof. And to go on to each of those, there are 6 of them listed in this case in particular. The Supreme Court came to the conclusion that no distinction shall be made between mitigating circumstances as set forth in subsection J of 39-13-204 and those otherwise raised by the evidence which are specifically requested to be instructed to the jury. In our view, the legislature intended this language as a mandate to the trial court to place all mitigating circumstances, statutory and non-statutory, on equal footing before the jury. At the beginning of page 32, the court states, "We think the trial court is prohibited from revealing to the jury that a request was made, nor should the trial judge identify the parties making the request. Only strict adherence to the letter and spirit of the statute will permit the sentencing procedure to attain the degree of integrity that is legislatively intended." In Hodges, State versus Hodges, 944 Southwest 2nd, 346, there were a number of very fact-specific circumstances that the defense proposed, 9 of them, which start in Section B regarding the specificity of instructions, starting on page 355. For example, As a result of his disturbed childhood and pre-adolescent sexual abuse, the defendant developed a severe conflict regarding his sexual identity, which he felt compelled to keep secret from his family. Obviously, that's not the case here. I only pulled that one out to illustrate the specificity that was involved in Hodges, just as we have here. And in that case, the trial court refused to give instructions requested by the defense and instead instructed the jury as to 6 general categories of non-statutory mitigating factors or circumstances. In that case, history of childhood, victim of child sex abuse, mental illness or mental or emotional disturbance, dominance by another person and or immaturity, drug abuse, and any other aspect of the defendant's background or character, or the circumstances of the offense which you believe reduces the defendant's blameworthiness. The Hodges court goes on to talk about the Odom court and says that in Odom that we rejected that claim, concluding that the fact-specific instructions advocated by the defense implied to the jury that the judge had made findings in fact in contravention of Article 6, Section 9 of the Tennessee Constitution. They held in Odom the specificity in the charge on non-statutory mitigating factors is inappropriate and cautioned that instructions must be drafted so that when they are considered by the jury, the statutory mitigating circumstances are indistinguishable from the non-statutory mitigating circumstances. Later in that same paragraph it says, however, when the defense proffers a requested instruction which is overly specific, it is incumbent upon the trial court to revise and generalize the instruction to conform with the evidence in the law. In the defense's 16, Your Honor, we have gone through and essentially categorized each of those specific circumstances proposed by the defense. In number 1, the state would propose that that falls under history of childhood. Numbers 2 and 3 fall under the mental illness or mental or emotional disturbance category. Number 4 would fall under family history or mental illness or mental or emotional disturbance. Number 5, family history. Factors 6 and 7 proposed by the defense fall under childhood history. Factor 8 would fall under family history. Factors 9 and 10 would fall under the mental illness or mental or emotional disturbance category. Factors 11, 12, 13, 14, and 15 would fall under the any other aspect of the defendant's background or character or the circumstances of the offense which you believe reduces the defendant's blameworthiness. Which actually is that language from the Tennessee pattern jury instruction is different than what there is there now, which is the same as what the defense has proposed in factor number 16. And Your Honor, the state has come to this finding based on what is actually in the Tennessee pattern jury instruction 7.04a, which is the pattern instruction for first-degree murder, fixing a punishment of death, or life imprisonment without the possibility of parole. And Your Honor, in the section dealing with mitigating circumstances, in the TPI they list out 8 circumstances, number 9 being blank with a note after that says, see footnote 10 when drafting non-statutory mitigators, and then a note to footnote 11, which I draw Your Honor's attention to. In that footnote 11, in the TPI, it states exactly what we're laying out here in our motion, or in our amended motion. The defense has submitted their non-statutory mitigators in writing, but the judge should never instruct fact-specific mitigators requested by the defense. And it goes on to list for the reasons why the court shall not do this. So, Your Honor, based on that, the state is proposing the factors that we've listed out in the amended motion, which would be State Filing 57, which was emailed, which includes family history, Actually, let me get my computer, because I didn't have time to print it out, make sure I get it right.
Family history, mental illness or mental emotional disturbance, drug use, and then the catch-all.
Thank you. That's it.
The drug use is not even a mitigator that the defendant has promoted either in the evidence at the mitigation hearing. The defense didn't put down any proof about drug use as a mitigating factor, nor have they asked for in their list of mitigators his drug use. Would you agree with that?
I would agree with that.
Then why would I charge drug use as a mitigating if neither side has actually brought that up or asked for it?
I don't think you would do.
All right. Just wanted to make sure I wasn't missing something.
No, you're not, Your Honor.
All right, Mr. Evans.
Judge, the defense would ask the court to deny the state's motion and adopt the revised list of mitigators that were provided in the draft jury instructions. I think the court has done exactly what the cases the state relied upon have suggested and complied with Tennessee Supreme Court precedent. It's interesting, in the quote they use in their motion from Hodges, it references, quote, "Finally, we emphasized in Odom that under the statute, a trial court has no duty, absent a timely and proper request from the defense, to include instructions on non-statutory mitigating circumstances. However, when the defense proffers a requested instruction which is overly specific, it is incumbent upon the trial court to revise and generalize the instructions to conform with the evidence and the law." And so what the state is asking you to do, Judge, is not take any attempt to conform with the evidence. I mean, mitigating factors can be narrowly tailored, should be narrowly tailored to some degree based on the evidence presented, and they can be attributable to that or corroborative of that evidence or in furtherance of that evidence, because that's what the jury heard. And to not instruct on them would put the defense at a disadvantage, and it would be in direct contradiction to the Tennessee Supreme Court precedent on this issue. Now,
Let me just interrupt you, and I apologize, Mr. Evans, but assuming, for example, that I charge a generalized charge regarding the mitigating factors, there's nothing that would prohibit the defendant from being able to argue in closing to the jury that the evidence that falls within that category. In other words, if I charged the mitigation of the defendant's family history, certainly you can point to every one of those pieces of evidence that you claim should be a mitigator that falls within the family history. And would that not be sufficient? I know you would like to have a charge go to the jury where it actually states the physical, sexual abuse and so forth, but is it not possible that you can still argue it to the jury despite the fact that it's not fact-specific like that?
So Judge, sure, we can argue it, but it still puts us at a disadvantage because Your Honor is instructing them on what they can consider, and it leaves an inference that that may be something they can't consider.
Conversely, by including all of that fact-specific language that you're requesting, I'm inferring to the jury that they must find those facts. Would you not agree that's the state's position?
I disagree.
Okay. I'm not surprised, but I just wanted to make sure that we were on the same page.
Well, the inference, what they're trying, if that were true, then the same inference would apply for the aggravating factors. By the mere virtue of you saying them, it means that you're saying they have to find them. And that's not the case.
That's a good point. I'm sorry, I cut you off. Go ahead.
Your Honor, we submitted versions, and I think exactly what Hodges and Odom, all of them contemplate, we submitted requests to Your Honor that were very factually specific. And the court, in its wisdom, went through and complied with this law and said, no, that's too specific, that's too specific, that's too specific, that's too specific. And has, I think, very rightfully amended this jury charge in an appropriate way. The last point I would make is it seems that the state is trying to set up a straw man in the jury charge. by asking the court to put in mitigators that we didn't rely upon or argue about, so they can then stand up and say, how dare they?
Well, I'm not going to do that because it's not appropriate. Mr. White even conceded it.
Yeah, so-
I think they included it because the facts at trial may have indicated it, but where it's neither requested, I think the mitigators are the ones that the defendant gets to identify which ones they're relying upon. The state has the right to argue about the wording of the mitigators, but it's not the state's position to say, hey, here's a mitigating factor. I understand what you're saying. I'm not going to include drug use as a mitigator because you did not raise that in your proof at the mitigation or at the sentencing phase, nor have you requested it, so.
And, Your Honor, if it were not, I think what the state is missing, they're asking Your Honor to give essentially a blanket list of mitigating factors. And what they're asking the court to do is not to tailor it to the proof that was presented at trial. And if this were not allowable, then Odom and Hodges there wouldn't be a section. Because they would say the court at any given time would only be able to say that very short language and allow people to argue, and that's not the case. It's not the case with any jury instruction. And the pattern, it is a pattern. That's by nature of what it's called. It doesn't dictate it and say, this is all you can say. The court has the obligation to raise these issues and to put it in the charge and instruct the jury. These were fairly raised by the proof. And everything that we have in our proposal that the court has amended was that, and it complies with the law, and we'd ask that it stay in the same version as was provided in the draft.
Anything further, Mr. Wyett or General Crouch?
Judge, one major distinction is the state has the burden of proof beyond a reasonable doubt to prove our aggravating factors. We can't argue any factors outside of those five, versus the defense, who, rightfully so, the jury just has to consider these circumstances and mitigation factors. That's great. The problem is this: the way the defense has proposed these mitigating factors flies directly in the face with the law. If you read the Odom case, Hodges case, the proposed mitigating circumstances were very fact specific, very just like this, just like they're drawn here, very fact specific. And those cases are a direct order from the Supreme Court to trial courts to not allow fact specific mitigators be listed in the charge. And that's why there's a footnote in the actual charge. Do not do this. I mean, just common sense tells you when reading through these. Number 2, the defendant has had organic brain damage throughout his life and has dead brain matter. That is a very fact-specific mitigating factor. That would go into one of many categories, and we're happy to let the court draft the broader categories any way you want. But this list of 15, 16 items is very fact-specific and directly against the Supreme Court's order and in violation of the Tennessee pattern jury instructions.
Well, as is usually the case, I'm going to take a recess and read these decisions before I make my final ruling, and we will be in recess until such time as I'm able to make that determination, and we'll return.
All rise.